All right, guys. So thank you so much for joining our Wednesday Zoom and Learn. Today, our topic is everything about signing. So we have a special guest, Samantha Hayes, who is going to walk us through the ins and the outs, the difference between, hey, we can see Mary Jane, the difference between
Yay.
What different signers are and who is eligible to sign and documentation that you need and what needs to be present on the documents and all that good stuff. And I may pipe in on, our number one things of why things get rejected at recording because of things that are on the grant deed or not on the grant deed or not visible, things like that. But I think she'll probably cover most everything for us. So those of you who don't know me, I am Tommy Dutcher with California Title. I'm the area sales manager. And if we haven't had the opportunity to meet or speak, please feel free to reach out to me. I will put my contact in the chat. I would love to sit down and see how I can help you in your business. And my co-host that we can now see, Mary Jane Morris. Oh, she's on mute. Let's get her off of mute real quick.
Yeah.
I did it. Whoa.
There you go.
Sometimes the simplest things worked for weeks and it doesn't work. It doesn't work. Hi, I'm Mary Jane from Granite Escrow. This morning or this afternoon, we've already introduced Sam, I believe, but if you guys don't know, she runs a 1,000-person transaction coordinator group nationwide. She's been TC a long time. We are soul sisters and forms nerds and best practice practitioners. So today we really wanted to talk about the constant errors that we're seeing with when you have somebody who is not an individual. If they are anything else, a trust, a corporation, an LLC, a managing member, an executor, a administrator, I'm sure there's more titles, member, managing member. If they are not an individual, if they are just not Tommy Dutcher or Mary Jane Morris or Samantha Hayes, how to fix that. And then we're going to give you the one little secret of what's causing most of your problems as well. The one thing we joke about, the dumb thing we keep doing that we could stop doing, make our life a lot easier. So without further ado, and thank you for your patience. Welcome to my Granite staff as well. I see Jonna down there. I apologize that I'm a little, the computer threw me this morning. Samantha.
Yes.
Staff for us this morning.
Well, thank you both for the kind intro, and I'm going to start sharing my screen because you can start seeing this instead of me. I have been TCing for almost 18 years. I'm a forms nerd. I also have a notary background. I've assisted with trust certifications, doing financial planning because of my sister. So some of these things I have familiarity with. I am not an 100% expert. Verify all with your broker of record, all of the disclaimers I'm supposed to tell you. But bottom line is, if you are doing a signing of any type whatsoever, and it is not your name, you need something to show that you have authority to sign. No matter what it is, no matter who it is, you need some sort of documentation and need to be ready to present that to anybody who requests because we need proof. So let me get you onto the next pages. No matter what, this is not a thing when your client says, oh, I'll get you the docs. If you are having contracts, listings, or agency, anything signed by somebody and they don't sign Sam Hayes, Tommy Dutcher, Mary Jane Morris, they said, oh, well, I'm signing for my entity, or, oh, it's for the trust. Get that document before you get started. It's going to be asked for multiple times, and that is one of the biggest delays we see and one of the biggest issues. Plus, you might not know how they sign or if anybody else is required to sign on behalf of that entity, and then you're going down a rabbit hole of mess. So that's always part of the fun and frivolity, but that's the biggest thing, is get the document as soon as possible. Proof of authority is to be provided within 3 days of acceptance per the contract. And this is one that we run into a lot. It actually just got added to the notices to perform. And what this means is, if you look down here at your bottom section for the double I's, shall deliver to the party and escrow holder within 3 days of acceptance. That's not escrow will provide you with the trust cert. That's not, we'll get the docs after we get into escrow. It's within 3 days. It is a contractual action that is required. And it's evidence of authority to act in the capacity, such as, but not limited to. So we're talking these certifications of trust where there is a document specifically in the trust that is created to show signing authority. We're talking about articles of incorporation, copy of the power of attorney to see if it even mentions that they're allowed to sell real estate. There are different versions of powers of attorney. Same with your LLC docs and everything else. So you need to see that, and it needs to be provided to both escrow and the other party. It's not escrow's responsibility to provide this document. Plus, the document that's provided through escrow is completed by the signer. So that's the equivalent of me saying, hi, I'm the Queen of England, and I'm going to tell you I'm the Queen of England, and I'm going to sign this piece of paper and say I'm the Queen of England so everybody will believe I'm the Queen of England. It doesn't work like that. That's when you have problems, and that's when you have potential for fraud. So, going into the main one you get into in California, majority of our properties are held in trust due to financial benefits and other reasons. There's two different types, specific major general categories. We have irrevocable and revocable. Irrevocable means the original trustee, the person who created the trust, has passed. There are no longer any parties that are part of the original creation of the trust, so there can be no changes to it. It cannot be revoked. What has been decided has been decided. Typically, those signers will sign as co-trustee, successor trustee. Again, that's why you need that certification of trust to find out who is supposed to sign. Do we have 4 cousins signing, or did they nominate 1 cousin to sign? I've had signings where I've had 9 family members that had to sign. I've also had signings where nobody disclosed we had a second trustee and we barely got the signatures in time to close the file. There's a reason this stuff is important, and there's a reason this is holding up your files. Asking these questions early in the beginning is really going to help you. It's going to keep expediting moving forward. The other one is revocable. That means the original trustors, Mr. and Mrs. Smith, who are living in the property, probably have the Smith family trust, and they do need to sign as trustees. The whole point of having these trusts is to provide protections. So every time you're signing, you want to make sure you're signing with comma trustee, co-trustee, successor trustee, whatever your title is, because without that, you're acting on your own behalf and you're not enabling the powers that come from these different entities to protect with their protections.
Hey, Sam,
The seller, yeah.
it's pretty common that even the people who have these authorities don't understand those authorities or even understand that they have a title. And part of the reason the CAR added this back into our responsibility, whereas where escrow used to do it fundamentally, and I even chuckled when they first started having agents do it because it's hard enough as an escrow officer to figure it out. But they want us to get into it sooner and start figuring out. I've had full people who own corporations have to call their lawyer and ask them what their title is. So it isn't uncommon that they might not know what needs to be done to find out.
Which is exactly, and that's why as soon as before you have them sign anything, if they tell you this is going on, or to reach out to Tommy and let's pull the property profile, let's take a look and see how the vesting's held, because as agents, that's our due diligence to be able to better serve our client and let them know what they need to get ready. And instead of telling them, hey, we need these docs, and they've already packed everything up in the garage because they're trying to get the house ready to show, and they can't get to them. It's going to take 3 days just to pull everything out to get that box that's all the way in the back shelf. So again, I agree with you completely. It's something that we need to do a little bit of research to get the ball rolling and then start asking questions. So with the trust is, the seller is the name of the trust because the trust holds the property. So it would be the Smith Family Trust signed by the successor, or excuse me, the co-trustees, the trustee, whatever is specific to that trust. But the seller itself is the trust. That's the big thing to remember with that. You also want to make sure you're double checking that with your listing agreements, because if you don't have it done correctly, that person can get out of giving you a commission because you haven't set up your agreement with the actual seller. So little details, little things that normally aren't a problem, but when they are, they're huge problems.
And they're things that will hold up closings.
Yes, majorly. And I know we're all working hard and things are crazy right now, but the more we can front load and the more education we can do with our clients and letting them know, hey, this is why we're going to need this, and getting in touch with the different parties, the easier and smoother the transaction you're going to have.
And from a title perspective, you know, while we're on the trust, we'll need more than just a recent trust cert. We will need a copy of the trust outlining within the trust who has the rights to that property. So keep that in mind as well.
Typically, what I'll tell my agents is, or when we're working with clients, is that we will need to have the trust available for escrow and title to review. The one specific document that typically should accompany with the RCSD is just that certification of trust, because I don't need to know who's getting what. I don't need to know about payouts. I don't care who gets the cat. I just want to know who's allowed to sign. That's my biggest priority.
And those books are often, especially for the people who did them during a more paper focused world, those books are 2-3 inches in notebooks. They're sealed into these pretty binders, that sort of thing. There is, as Sam was saying about, we don't need to know who gets the cat or who's getting the money. And so very often we can get away with what they call pertinent pages, the pages that have the powers, the final signature, and the notary pages, so that we can get it down to 10 or 12 or 20 pages versus the 200-page full document.
I know this is coming up a little bit more in my world with a couple of agents I'm working with. Probate administrator versus executor. An administrator is when there's been no will left and they were appointed directly by the court. Executor is when they have been nominated by a will, but it's still going through probate. What you do is that your seller is the estate of the individual they're signing on behalf of. So you're going to say estate of Joe Smith, and then each person was going to sign on as with their title. So I would be Sam Hayes, administrator, Sam Hayes, executor. You will get court documents, and you need those because you need to know if it requires court approval. There might be where the court has to decide if this is allowed to sell, or if you can just go through and the administrator has all the powers. Again, these are documents you're going to want to have on hand before you start taking your listings or before you start doing any type of transaction, because the more you have ahead, you can already have everything lined up so you can be ready to respond when you have all these offers that are coming that I know we're all going through on our listings. Another one you see a lot of, especially with anybody who's doing any flippers or doing any remodeling, is we've got entities with the LLCs, LPs, or incorporations. The LLCs, typically the members are the signers. We need to see the operating agreement so that we have that information. The LLP, the general partners who will sign. We don't want the limited partners signing. They don't have authority. How do we know who they are? We need the documents to show who's got signing authority and who doesn't. With a corporation, I don't like if you're dealing with REOs, which will be at some point probably coming up, relos, different business entities. If you have a corporation, we do need the corporate resolution that is generated, and that is created by a third party, typically the secretary or someone on behalf of the board, stating that this individual does have signing authority. So the thing that go ahead.
Came in from Daryl. He said, does the seller need to provide an EIN number for irrevocable trust?
That would be a escrow question because I don't get into that, but I would believe so, since
escrow will, but the realtors will not.
Correct.
I don't want that purposely. Okay. But yes, any of these also will be dealing with that with escrow and title, with any tax issues, transfers, and those type of things. That would be more, I defer to Mary Jane and Tommy to answer those questions.
Yeah, I mean, title's going to be running the backgrounds and stuff of the LLCs, the LLPs, the corporations, the members and the general partners, et cetera, of them to make sure there's no judgments, things like that. And then escrow will be handling the tax side of it.
Power of attorney is another one that comes up. We have general. You can do almost any act. It is terminated when the principal is incapacitated, passes away, or revokes the power. You have durable power of attorney, which gives another person specific powers, including stating about the ability to sell real estate transaction, and you need to make sure that the property and the details about the property are clarified within that power of attorney. Same thing for specific. It needs to show the property address, APN. It's the more detailed, the better, so that we know that they have the authority to sign on behalf of the other party. Mm-hmm. And that signature is one that comes up a lot. Tommy?
I get this one a lot, especially on the general, and especially when somebody passes away. Guys, power of attorney is exactly what it calls for. And as soon as that individual that you have the power of attorney over passes away, that power of attorney is null and void. So it is only good to act on their behalf while they are still alive or incapacitated. So, you know, keep that in mind, that if you're in a situation, because I get this call at least once a month where somebody has a power of attorney for a loved one, they're in the hospital, the loved one passes away, and they think they still have the power of attorney to act on their behalf as a signer or be able to sell a property, et cetera, and that is not the case.
A quick way to remember that is powers die with the person.
Now, if you two run into the issue that I've had several times, well, the trust gave me a power of attorney. I'm like, the whole point of a trust is that you don't need the power of attorney.
Correct.
It directs everything if the individual passes away. I think I've seen one time, and it only because of the way it was worded, we got it through, but trust never, typically never, like 99.9%, you're not going to have a power of attorney on behalf of a trust. That's just not
No,
why
I have seen a power of attorney written within a trust, just so that if somebody is incapacitated in the hospital, not able to act on their own, that all documentation is done already, that you have the ability to act on their behalf, regardless that they haven't passed yet.
Okay, but once they've passed.
Correct. Then the trust basically is in control.
Okay.
Yep.
Because that was the situation, as we had it started with the POA, and then they passed in the middle of the transaction.
Yeah, and at that point,
that does happen.
The trust is the override on it, correct?
And it brings us to another thought, that power of attorneys are like Tommy was saying. There's a whole bunch of different kinds.
Yes.
The trust the bank doesn't want to take. The one the bank wants, the trust the title insurance company doesn't want. The one that the escrow drew, the bank doesn't like. And so there are lots of versions of power of attorneys. One of the things I wanted to reassure you is that as you collect these materials, you don't have to examine them or know that they're right. You have to get them into the hands of the parties who can review them and tell you if they're right. And this will give you a great paper trail. Oh no, we need one more thing, or we need 2 doctor's notes, or we need whatever it's going to be.
Right.
You don't feel like you have to be an expert. Just be aware that if they are not an individual, you're going to be looking at additional steps. So I just wanted to mention that you don't have to be an expert. You just have to get them into the hands of your team.
Yep.
It's kind of like a tickler red flag, so that as soon as you know, then you know to start reaching out to your title officer, your escrow officer, which again, as we've all talked about, one of the benefits of having a team you work with is let them know when you're taking these listings. They want to help you because everybody's much calmer, and it's much easier to get things processed and lay out the groundwork, because then you're managing expectations for your client, you're setting up everybody for success, and we're streamlining the process. So the more questions you ask during that time of connecting with your client originally, the better you can serve them overall, and let us step in as your support team to help you look like the rock star that you are.
No charge, by the way.
Bottom line, why is it important? Why does it matter? Well, you've got the protection of the entity. The whole reason you're signing with these titles is these entities were created for protections. It can cause delays in closing, as we have all discussed here, that it can be problems, and then you have to redraw, or title can kick back and you can't record that day, or the lender kicks something back, or there's so many layers that this could then cause delays and having to chase down and reformat documents and get wet signatures. And you're a professional resource. As Mary Jane was saying, you don't have to be the expert, but you know where to get them to. It's part of our job as realtors to know what's going on so we can get them to the right person. It doesn't mean I know every single bit about this, but I know enough to go, oh, I see this word. Let's get you over to title. Or, oh, okay, you know what? Let me get you to an expert on this, but I want to make sure we do it correctly. So again, it's an opportunity for you to provide service for your clients. So if anybody has any questions, let's hear them, but I will happily talk forms and this stuff anytime.
Let's tell them about the most common mistake that's messing up their signature lines, Miss Sam.
Oh, trusts don't have hands. None of these have hands. So you can't, signing as, I should have thrown that slide in here because that was in my last presentation. They don't have hands. The Smith Trust cannot sign your documents. The
Right.
ABC LLC cannot sign your documents. The power of POA, putting your name and then POA behind it, is not going to sign your document.
I actually meant the
Which one are you talking?
that happens when you have your DocuSign attached to your zip forms, or your e-sign attached to your zip forms. That's the one I was talking about. So
Because I always set mine up so that it signs correctly in those. So I'm not sure which one you're talking about.
So the most common mistake I see when agents call me about this is that they think whatever they type on zip forms, meaning the actual seller, which Sam has clearly described as the trust or the entity or whatever, when they have their DocuSign already linked and the DocuSign helps you, or the e-sign already sets up the signatures, that's why you're getting the signature that says Sam Mays Trust instead of Sam Mays, trustee. If your e-sign is attached to your zip forms, you will need to edit those signatures back to their authority. Mary Jane Morris, president. Mary Jane Morris, administrator. So the reason you're getting signatures that say the whole trust name is because you put it on the zip, it was on your zip forms, which is correct for your seller. But for the signature, you need to edit it.
You need to go in and look at it.
Me personally, I was just old school and I have mine separated. And so when I pull out of one and go into the next, I'm just automatically thinking about setting it up top to bottom. But as I noticed more and more people were attaching their e-sign, I'm starting to have, that's for sure 90% of the mistakes I get where the entire trust name has been signed with hands they don't have, is because they did not, the person who set up the e-sign did not edit the signatures to say Tommy Dutcher, vice president, Tommy Dutcher, member. So remember, if you have it attached, you need to edit your signatures.
So we do have a couple questions.
Well, and going along with that, one trick.
Go ahead, Sam.
Oh, just one quick trick to go with that you can do. In WinForms, if you only have one signer on behalf of the entity, what you can do once you set everything up in there is you can go back in and set up that your seller number one is whoever is supposed to sign with their appropriate name and title. And then seller number two, I always put the name of the entity so they always populate on your different documents. That way you've got a little bit of extra info on each one, but it depends on each file. But that's one trick that's worked a couple of times.
Okay, Christina had a question that said, if I have a RCSD, do you need to add a trustee after signature? Question mark. She says, I thought that was the point of the RCSD.
The RCSD is a car form, and so for me, as I'm a belt and suspender kind of file person, I have them still sign with the title, because the thing is that is a specific to car disclosure. That's not a general legal document, and all it is to clarify who signs on behalf. I still have them sign it. I don't see any harm to it, and all it does is keep the protection going. But
they
I
should
defer to Tommy.
always sign with their authority. Sam's absolutely correct. They should always sign, whatever their authority is. The purpose of the RCSD was twofold. One, to help you know that you need to find out before you get to escrow, which is what mostly happened before. And second of all, is to connect the dots that this trust and these people go together. And what is their capacity? Are they a successor trustee? Are they a trustee? Whatever. That brings those two things together. The purpose of the form was to give agents a way to figure out what they need, and more importantly, what they don't know. So if you present this form and you don't know what their capacity is, and they don't know what their capacity is, there's one more phone call that's going to need to be
right. She said in there, AuthentiSign in zip forms now has places for the trust and places for the signer. Maybe one of you guys may have some insight on that, because I don't.
It breaks it. I've seen it where it breaks it out. I still do my little trick because I don't trust it, because I've run into the problems once you're inside. But it's little tricks you can fix in DocuSign if you have to. Just knowing familiarity with the different software. basically get familiar with whatever tools you have so that you can do it, so you have the correct signature block is what I would suggest.
Gotcha. All right, do we have any other questions? Feel free to take yourself off mute if you have a question, or put it into the chat, either or. If you're on mobile, sometimes it's easier just to speak it. It is extremely common not in every county, but in most of Southern California counties where we see recordings get pulled because, one, it doesn't have your suffix or what you are, right? You are the, what type of signer you are, or it is missing words. So somebody, like I had one 2 weeks ago where, and I'm not going to use the name, but I'll use like Samuel L. Jackson, right? But he signed it Samuel Jackson, and it was perfectly viewable Samuel Jackson, but the signature line said Samuel L. Jackson, and it got pulled for that because he didn't put the L in there. Little things like that are what cause things to be rejected, and it sounds extremely remedial, and it is, and it takes 2 seconds to fix and send back in, but not all counties can you record back the same day. You know, that, or, you know, the signature line doesn't match. You know, they listed on the signature line the trust, and then you have a person that signed with no other data. So we see this quite often, and that's why it was worth having this discussion today, because the last thing we want to do is spend 30 to 60 days in a transaction, and it went longer than expected, and we finally get it recorded, and then it gets spit out at 4:30 p.m. Right? That's the last thing anybody wants to happen. So we're just trying to catch this. And a lot of times, you know, you as an agent, you're not going to see this stuff, right? Because it goes to escrow reviews it, it goes to title. And a lot of times people say, well, how could somebody not catch that? Well, let's think of it this way. Escrow gets documents at 10:30 a.m., has to package them together. She's putting them all in order. She's in a rush. She's getting it messengered down to title so that title can get it in time to record by a deadline of 3. And really, they need it by 2:30 to do that. And nobody has time to go through, and we have to abstract it at title. That takes time, and then upload it electronically. And somebody missed a middle initial, right? That's how it gets overlooked, because we're rushing to get it done that day for you. You know, so unfortunately, is a lot of times, especially in today's age, it comes down to a rush where everybody's rushing to get it done today. And, you know, so if you have the ability to look through certain things, because it really starts with your contracts and everything else. If the contract is stated one way, that should flow through the whole transaction. It's when things start to get pieced together halfway through the transaction and they didn't start appropriately to begin with, and there was addendums and different things that changed verbiage or names or words, and by the end of it, something gets overlooked, right?
Well, and that's where the AOAA comes into play, where we have the assignment of agreement addendum, and it states that you do have to have the RCSD. So one of the notes for the upcoming new contract later this year is they're not going to require, say, I was buying as myself and then suddenly go, oh, they're going to let me put in my trust. I don't have to sign one of those for that, but I still need an RCSD, and I'm still going to have to prove to you that I'm allowed to sign on behalf of my trust. Even if we switch it at the last minute, I still need all that documentation. So anytime you're not signing on behalf of your own name, or anyone's not signing on behalf of their own name, you should be asking for paperwork. Because there's no way, how do you prove? And unfortunately, fraud is prevalent. And a lot of this, too, bases off of people going after seniors and making sure that there's appropriate documentation that people aren't losing their life savings.
Right. And if you're dealing with an entity, okay, of any sort, it could be a trust, an LLC, corporate, any type of entity. As an agent, you should be right off the bat asking to be copied on everything that needs to be signed to make sure that it is put on there properly, right? I mean, you should be copied on most of the stuff anyway for your file, but ultimately, on those types of transactions, as an agent or as a TC, you have to really be over aggressive and do your due diligence to make sure that everything got done properly, not just the first signing or the last, but everything in between. Because, like I said, most of the mistakes start because things were pieced together. If it was done right from the get-go, the contract and everything was written up appropriately and the right way, those tend to go fairly smoothly. It's when they weren't and it was written in someone's name and they go, oh, it's a corporation, and they do an addendum for the corporation and all the other stuff starts to play and get pieced together. That's when the mistakes tend to happen. You know, it's a little different than just a standard transaction where Tommy Dutcher is selling a house, right?
I want to talk to Londa's message in the chat that she says that people get indignant when she asks them for proof of signing authority, especially.
They hate me. They hate me. I ask all the time.
First of all, I totally agree. And I'm also a licensed broker, so I'm gonna speak to you from that side as well. And that is, for all the files I managed all these years, 10,000 or something, I very rarely actually have the pertinent pages or the FERC trust or whatever. What I have done is requested them, started figuring out who doesn't know. And then when I hit the problem, I kick it up the chain. Escrow needs it. Escrow, could you please request from them what you need? Title needs it. You don't have to be the bad guy. There are people who legitimately need these things beyond yourself, and you can circle back and pick them up somewhere else. And then in general, I wanted to remind you that when I hear anger in my business, and this is just purely experience, I immediately equate it with fear. They don't know, they don't want to say so, they have no idea how to solve that problem. They're not even sure how to say what do you mean? So yes, you are definitely going to hit that problem where she's dead on. That is definitely going to happen to you. Your job is to keep kicking the ball down the field. It's a team. We're not all going to be scorers. We're not going to put it in the net every time. But we do have, and sometimes we are, sometimes we're lucky. We're the ones that gets to get the big prize at the end that we save the deal. But just don't let that intimidate you. Take it as a fear response, and that you're going to have to circle around them. And then the usual stuff that your broker tells you, where you ask 3 times and you have the emails, because frankly, escrow and title will require these things for sure to do a transaction. And that's why we've all been getting away with it, if you will. It gets past us, it gets solved at the level where they need it, where they actually have to have it and can't live without it. So I agree with you that in all the files I reviewed, I very rarely see the actual document. The RCSD that's another purpose for the RCSD, is to at least give you a clue. What you're heading at, and more importantly, what you don't know.
Don't try and be the expert of all of this. And what I kind of mean by that is everybody needs to kind of stay in their lane a bit, because for instance, we ran into a file issue where somebody had dealt or done their first transaction with a trust. And after doing one transaction, thought, oh, I know exactly what I'm doing. And the next transaction with the trust, the broker mentioned to them, make sure that they're going to need a trust cert. The agent went out, asked for the trust, drew up a trust cert, and got it notarized with them. Don't do that. Because here's what happened. That trust cert was not written properly based on what the trust stated. And nobody caught it till the very, very last second. And it held up recording that day, and it didn't record till the next day. At least it didn't get recorded and get rejected, but nevertheless, still held it up another day. Everybody has their process of who does what, and escrow will help you draw up that trust cert and everything so that it gets notarized when everything else gets notarized. And all that stuff should match up, right? So yeah, don't Don't go above and beyond. Just gather all the data, gather the trust, gather the LLC documents or the corporation documents, all that stuff that needs to be gathered so that you can get that to escrow so that things can be drawn up and made sure things are drawn up properly and then signed once, right?
Or like I said, if no one knows, that's your answer. Not all first requests get the entire what you need. You know, it develops. I took a 2-hour call yesterday to sort out a transaction, and the deeper we got, the more things got revealed. So what they called me for was miles from what we finally decided 2 hours. 2 hours later.
Well, that's what they say. If you find one
circles,
issue, there's probably underlining issues as well.
which circles back to asking a lot of questions when you're taking that listing. And none of us can give legal advice. None of us are lawyers on here. All we can do is state what is in the contracts and what it says to be provided. And let's get it, as you said, to the experts. I mean, nobody should be drawing up docs. These are things that should already exist if these parties are signing on behalf of entities. So the whole point of this is just to be aware of what's going on and ask more questions and get some info before you lock yourself into a transaction and go down a rabbit hole that's going to take away from your other files and your other business.
All right. So do we have any more questions?
I did re-upload all of those. Those are from CAR. Those are examples on how you're supposed to sign the RCSDs. The reason I did not share the RCSD is it's going to be incorporated in the new contract in the fall, and they're doing some other tweaks. So it's kind of one of those things. There's enough changes coming up that I didn't want to show you too much, but that's at least what CAR has currently under their education center.
Sam, you couldn't have set me up perfectly because that's exactly what I was going to talk about. So I'm going to ask Sam to give, I'm going to put her on the spot, and so don't worry if you don't have exact dates, but the rough schedule of what the new contract rollout looks like that you sent out this week, I'd like you to talk about that.
Oh.
But I also wanted to mention that the reason they're doing that is that they're taking all the things that were dates and putting them together, and all the things that were contingencies and putting them together, and all the things that, you know, we don't need to read so deeply are, you know, other places now. So we are going to have new holes in this new contract that we're not used to answering for. It's going to cause a ton of confusion at the beginning before we either learn how to do them or go back to ignoring them, which we've been doing pretty well with the contract we have now. But having said that, the RCSDs now is going to be worked into the contract, is going to bring it front and center for agents who have been avoiding that. But Sam, tell us how the rollout schedule looks for this year.
So I was able to sit in on the CAR class last week that they opened up some of the meeting, because of COVID, things were done remotely this year, which gave some accessibility. Currently, they should have the final draft available approximately a month from now. They're saying mid-March. Training should launch approximately August to get everybody started. There will be all sorts of classes. You will see them nonstop. I will be taking as many as possible. Those of us that are CAR Forms trainers, they've suggested we wait. I'm due for my renewal, but everybody's been suggested to wait till late October so that we can be certified on the new contract to be ready for the rollout in January, late December, January.
At that time, we will, the same for any of these classes, we will teach them to you individually if you're in need. We will teach them to you in 2s and 3s if that's how your office is. If you want us to do the whole office 2 weeks in a row because half the office wasn't there the first time, please schedule with us. Whichever one of us or all three of us, including the Granite team, that is who you feel most comfortable reaching out to. You can have all of us or none of us, or one of us, I meant. And so we expect to be teaching that class 30 to 50 times before the end of the year. So, and then another 300 phone calls to go with it. So please, and we'll be pressing you to sign up for those as we go, because we want to get you guys past that hurdle. The last contract change in the last big change when we went from the
14
to the active system was in January 2002. That's how long basically this contract has been has been standing. So
Yeah, the last big revamp was 14 that they did when they changed a couple of the, I think it's when we changed 10 pages. But yeah, this is the next biggest one that they've done in quite a while. The other thing to bear in mind is I would suggest is you've got two major things to piggyback on Mary Jane. Your time frames are changing big time in the new contract, and I would suggest wholeheartedly as soon as it is available on CAR, where they've got the red line version that this is pretty much the final, start reading it. Just read it over, and even if you don't understand stuff, take notes, but start reading it, get familiar with it, get comfortable with it. The more you do that, the better you're going to be able to go through, and it's going to keep your business flowing so you're not stumbling on it. We don't have stumbling blocks. That's the biggest recommendation I can give you.
I think you probably have handy, if I don't put you on the spot again, Sam, can you load the link for the listed,
Sure.
the existing red line version?
Yep.
My favorite thing about that is because it's a red line version, you can see what was different from the old contract. So if you put it in black and white, it's not going to print with the red.
I think I've got a copy of it.
But for reviewing it, you know, on the screen, you're going to be able to see the proposed changes. This is not the final draft, but this is pretty close.
Okay. Let's see if I can find it.
In the chat for you.
Yep. let's see.
No, when I was in secretarial school a million years ago, they told us when we were proofreading something or learning something new to start from the back of it. Take one paragraph, focus just on that paragraph. Don't try to bring one into two, into three. You can, so, I mean, you can take apart a whole paragraph and not absorb the whole thing every single time you sit down to look at it. Just try to get a little grasp on how that paragraph changed, or what is causing you questions, or what fears you have that your team's not going to be able to adjust to. Take it in. You can't. What's the saying? You can't eat an elephant in one bite, or something. I forget what that saying is, but something like that.
Well, once that happens, we'll have a Zoom and Learn on it, and then you'll be out about doing classes and training. So
hopefully I'll have a vaccine by then, and we can start seeing each other again.
I don't know. I kind of like, I like that, but I do like the Zooms. I think it's better because everybody's able to record and go back, so it's a little more flexibility.
I really do feel like the world has turned on that. I think a lot of things we've all come to love. Sam and I have to take our certification class every year. And now they're doing it online, so we don't have to try to park in LA and find your car again. It's the only time I've used my parking app on my phone is when I had to basically hide my car in LA to park somewhere near the car building to get back to my car. So
well, the RPA is uploaded in the chat if anybody needs it. Otherwise, you can just go on